2026 meeting of the Montana Sexual Assault Response Network Committee. We thank everybody for being here today. And we are going to have a continued discussion on minor self-consent to sexual assault care, taking a look at an updated legislative draft that we've been discussing in the background since our last meeting in April, and looking forward to seeing what happens with that discussion, and also where we might go with the SARN budget proposal as the Law and Justice Interim Committee for the legislature continues that. I don't have an update today on whether they'll take that up again at their July or September meeting, but that discussion is also still going on in other sectors. So I'll give you more information as I have it, committee. And let's get started today just by going around here with member updates. Jordan, I'm going to start with you, please.
Hi, I'm Jordan Kilby. I don't have any updates, but thank you very much.
Appreciate you being here. And Ben?
Good afternoon. I don't have any major updates, just getting into the summer and enjoying the beautiful Montana summer weather.
Indeed. And good to have some rain too with it. Brett, you're going?
I am currently finishing up a response to a motion to suppress and dismiss regarding the grooming statute that we got put through this last legislative session, and the challenge is that it's vague and overbroad. My response is a lovely 17 pages, which is a lot longer than I typically like it to be, but trying to do my best to make sure that that gets upheld when it's appealed to the Supreme Court, because I'm sure it's going to be. I think we may have been the first county to charge somebody under that grooming statute. So it'll be interesting to see how that kind of shakes out in the district court, and then ultimately, I'm sure, in the Supreme Court as well. And I don't have a nanny today, so I'm home with my kids. They're outside playing. So if you see them come running by, that's why. And I've got my dog Louie here with me, so he's keeping me company while we go here today.
I was just going to say kids, dogs, and cats welcome. So I'm
glad you might hear some of
it. Very well. Thank you. Emily Mangus.
Good afternoon. No big updates here. Other than I got to go help with the MSU clinical skills over in Glendive, and it was really exciting to see people on that side of the state like really dig in and want to take up the work of forensic nursing in their communities. So that was really awesome. Other than that, no update.
Definitely exciting to get people trained in that part of the state. Thank you, Emily. Sergeant Gadarian.
Hello. I am on night shift, so still trying to wake up. The only update, I guess, or thing that's been brought up to me is that we're still having quite a bit of an issue as far as getting SANE kits done and sending people to Helena, and I guess working with Helena. From what I've heard, I haven't witnessed it firsthand, so I might have to hit up Whitney a little bit later regarding that.
I know there's a conversation in the community, and I've been contacted too about that. So we'll just see if we can keep conversations going. Yeah, thanks. Whitney, your turn.
Hi, everybody. I am excited, like Ben, to start enjoying the Montana summer weather. Our family purchased a pop-up camper this last couple of weeks, so we're excited to take that out this weekend for the first time. Other than that, been doing a lot of training. I was with Emily in Glendive, and that was really exciting to meet nurses from Glendive area, Sydney, Williston, North Dakota, and then there was a couple kind of scattered throughout too, but it was really great training. And then on Tuesday and Wednesday this week, we had our rescheduled adult skills lab in Great Falls, which unfortunately, I don't think we actually had any nurses from Great Falls there, Kara. We did have some from Shelby, from Lewistown, from Bozeman, and from Helena. And so that was canceled in March due to the weather. So we got that rescheduled, which is great. And yeah, just a lot of training. So I'm excited to be home and excited to go camping this weekend.
be pretty good weather too for that. Christina.
Well, it's been so crazy busy down here that I'm sure that we should have all sorts of updates for you, but I can't think of one of them, not even one of them. So it's going down here.
Fair enough. Mark?
Good afternoon. Yeah, no updates from my end, just plugging away here in the office. So looking forward to warmer weather. It was really windy here last night, so a little bit of rain.
Yeah, the wind is a thing for sure. Brett Taylor?
No updates from me, but are we going to get summer this year? It's kind of like the never-ending spring/winter.
I have no doubt, no doubt, Brett. I'm a believer. I just hope it's not just a fire season as opposed to a summer season.
Let's hope.
Yes. See, I'm just checking here. Stephanie Robles is coming into the room, so we'll check in with her in a minute. But in the meantime, let's see, Suzanne, I'm going to call on you if I can.
Hi there. The only thing new on my end is that I attended the prosecutor law enforcement training that Hope and the Montana Board of Crime Control put together. It was a great training. It was good to see what they came up with on a shoestring budget. So
We had some good options. Thanks, Suzanne. Let's see. Stephanie Robles, hello. Any updates for you today as we go around and reconnect?
Hi, everybody. No, nothing. No, I don't think so.
Very well. Good to see you.
You too.
And Emily Cantrell.
Hey, I don't have any updates. I will have to jump off. I apologize in advance. I'll have to jump off in about 15 minutes.
Know that you have another meeting going on today, so we appreciate you being able to be here while you can. Thank you very much. Suzanne mentioned the May training that we held. It was a joint prosecutor and law enforcement training out at Fort Harrison here in Helena. We had about 75 people from around the state, about half and half law enforcement and prosecutors. Really good turnout. We had support from the Board of Crime Control's TTAC grant to have 2 trainers from Equitas here. And we had local DCI agents, Helena PD helping support the law enforcement specific sections, as well as the FBI's VICAP analyst, crime analyst for our area, Melissa Kovetsky, was here all 3 days. So really had some good discussions, I think, and look forward to planning another one hopefully next year. So let's see. I am going to go ahead, since Emily cannot stay very long, I'd like to go ahead and hop into our primary discussion today on the minor self-consent to sexual assault care. I sent the updated draft to committee members on your meeting bug to have at hand. It's also posted on our website for members of the public if you'd like to refer to it. This came out of continued conversation between our April meeting and now with the nurses on the committee and the prosecutors on the committee, and much discussion about different potential options for would this be a standalone item? Should it be something that's embedded in the existing statute related to minor self-consent to other types of healthcare services? And so I don't want to take discussion from any of the members who are part of that and who might want to share their perspectives from anybody. But Emily, do you have anything you want to share before you are having to leave today as we get started with this conversation?
Sure. It's probably not a surprise to anyone, but our recommendation is the same. We don't recommend moving forward with this because we believe you already have the authority, and actually moving forward could put that at risk, which I know we've already had that conversation multiple times. That's the viewpoint of our office. And if the committee does decide to move forward with the proposal, they'll have to do that without the support of the Department of Justice. So the members would need to take that on and find a legislator. But I do want to be clear, we do support your work and we want children to be able to get these exams. We just already think you have the authority and we don't want to put that at risk.
Thank you for sharing the comments, Emily, just so everybody's got a good foundation of that. Let's see, Brett Irigoyen and Stephanie Robles and Whitney Brothers and Emily Mangus were all folks I talked to in the course of putting together the draft that's in front of you today. Do any of you want to talk a little bit about your thoughts on this? There was a word highlighted, for instance. I'm just going to make sure I've got this pulled up so I can see it. This, just as an overview, I guess, is a good place for me to start. This incorporates, it takes the same strategy as the original version you saw back in December and that you talked about in February. It incorporates Christina's comment from the last meeting about offering an exception about when health professionals have to attempt to notify parents or legal guardians about the care, to include if the health professional reasonably believes that notification would result in harm or threat of harm to the minor, not necessarily just because the parent or legal guardian is the suspected perpetrator. And so that is incorporated. And then I've also highlighted in the draft that's in front of you today, the third word in this new subsection E on the bottom of the first page. When it says the minor presents, that verb is different than what you saw in previous versions. And maybe, Stephanie, I'll ask you if you want to talk a little bit about that word and why you were more comfortable with that as an option than some of the previous language.
Sorry, Hope. I have court this morning and I was appearing from the vehicle, so sorry I'm on the road here. So I think that originally the original word that we had in that, I hope I don't have it in front of me. We changed it to presents. That's the section that you're referring to, correct?
Yeah, it was the minor is let me pull that up so we have it for reference. That'll just be easier.
I think it said the minor professes to be or is suspected to be a victim of sexual intercourse without consent, sexual assault, or incest.
Mm-hmm.
Perfect. Because I think with the professes, that's just a pretty I think when you have somebody who presents as a victim, then it kind of gives the leeway of if you see where somebody may be a victim of sexual assault or that examination may be necessary, it gives the leeway to conduct that exam. Whereas professes requires or kind of implies that it requires a child to, fully disclose all the details of a sexual assault exam, which I think can sometimes be a challenge even with a very trained forensic interviewer. So if you have a child who comes in and doesn't have the correct words to describe it or, things like that, I think it gives the provider the leeway to do an exam where they feel like a child's presenting and has the indicators of having been sexually assaulted. It gives them that leeway to do the examination.
Brett, being the other attorney in that conversation, do you have anything you'd want to add there?
I think that sums it up. I think presents encompasses both professes to be or is suspected to be, and potentially other situations that we may not be thinking about. I think presents kind of encompasses all of that.
I think anyone could come in and profess to be something, but I think presenting is kind of more of a term of art for a medical professional as to, maybe a piece of the medical puzzle they're trying to solve or, for the patient when they're there.
Molly Mangus and Whitney Brothers, any particular thoughts you'd like to share about that or anything else in the updated draft that's here today?
I think the word presents is fine. I do wonder if we need to consider the language of victim in this, since we just had a Supreme Court ruling, I feel like, that says we can't refer to an individual in a courtroom as a victim. So do we want to take that out of our like legal language in this statute. This was my second favorite of the four proposed. I do like the fact that it allows us to use some clinical judgment around patient safety in when we notify parents or how we notify parents. So I think it's a step in the right direction.
I don't think I have any additional comments. Hope.
Okay.
The only question I had is to counsel the minor, like, what does counsel mean? Because
There's
that
some
can be
discussion around that too. Yeah.
that can be interpreted many different ways.
I am remembering that was a question that I had at our original meeting.
Yeah. And to refer them to, health professional for counseling, it can be interpreted in many ways.
The origin of that word, oh, sorry, Emily, just as a reminder, is that is something that's in the subsection C a little higher up in this statute. So that language is being mimicked there. You could certainly choose to write something differently. But I think in the conversations we were having between last meeting and this meeting, Emily and Whitney particularly both raised that question. Is it educational counseling about impacts, or is it mental health counseling, or what is it? Sorry, Emily, do you want to take it from here?
I was just going to say, I feel like we sort of settled on it being counseling equals education around risks and benefits of receiving care and what that might look like. But I think if we wanted to change language and not mirror what was in section C, I think we could do that as well. I don't think we really thought at any point in time it was like referring for mental health counseling. It was more like if the nurse doesn't feel like they can do proper education, then we're bringing in a provider to do education on maybe like the HIV medications, or a portion where maybe the nurse needs additional help in that education process.
And then Emily also mentioned that this was her second preferred version of a few versions that I noodled on. The other versions were a standalone version that was its separate statute, standalone, and I think the consensus among Stephanie and Brett as they looked at that was that that maybe presented more risk or would not be as well received as something that's incorporated into the existing statute. And Stephanie and Brett, I'll defer to you on those thoughts. Another version that I noodled on was incorporating sexual assault care into this subsection D about emergency care and somehow trying to include it in the definition of emergency care. And as the conversations progressed, it seemed to get a little bit more awkward to think about how to try and make that part of emergency care, particularly if it was a delayed report and somebody was getting an exam, a few days or many days after. So I don't know if any of the four of you want to comment on any of those things.
I guess I can comment on the standalone. When we discussed that, we just felt we'd have less luck with a standalone than incorporating it as part of the existing statute. I think it's a little bit easier pill to swallow if you can read it in the entirety of the statute, seeing that minors are able to consent in various situations, including in the situation in which a SARN is going to be conducted, as opposed to a standalone. I feel like that's a little bit tougher sell when you can't, I guess, tack it on, if you will, to other rights in situations in which a minor can consent to care. That was kind of our thoughts.
Stephanie and Brett did ask me to look at what other states around us do in that regard. And so when I looked at the statutes, I looked through North Dakota, South Dakota, Colorado, Washington, Wyoming, Oregon, Idaho, Utah, Nebraska. Idaho, Utah, and Nebraska do not have statutes on minor self-consent to sexual assault care that I could find. North Dakota, South Dakota, Colorado, and Washington, four, do have standalone statutes. I did send you, I believe, the document of sort of the raw statutory language from those other states so you could take a look at those. And then Wyoming and Oregon had embedded their statutory language in a broader statute of some kind. They did it in different ways, but just for some reference of what states around us are also doing.
Thank you for sharing that, Hope.
Christina, since you had brought up adding that additional exception language related to other circumstances that a parent or legal guardian might not be notified or attempted to be notified, how do you feel about that double I language? Does that seem to get to what you were looking for? I'm not hearing your voice. Saw your head nod, and I think I see your lips.
Yeah, I'm looking over my
moving.
shoulder and reading it on another computer.
Yeah.
So yes, does reasonably believes, is that protective enough? Oh, it's right in front of me. Well, that's so much easier. Protective enough for medical personnel?
I think it's helpful. I think ideally I would just like the notification of parents not to be in there, but I recognize I don't think I'm gonna get that wish. So it makes me feel more comfortable. Yes.
I would agree with Whitney. Ideally, it would be great if it wasn't there, but I think this at least gives us an avenue to be able to document what the threats of harm or the harm that might result, and then we have that as backup to this statute for not
Okay.
notifying.
But you like the words reasonably believes?
Yes.
Okay.
When I think back on the cases that this statute would directly impact of the care that we've provided to minors in the past, the majority of them, I feel confident that I had reason to believe that notifying parents would have created more harm. Not all of them, but the majority of them.
Okay.
Jordan?
Thank you. Yeah, I think the reasonably believes language, though, brings in an objective standard, right? So if it just said believes, then we would be just deferring to the healthcare professional. So that's one thing. And then the other is I agree with the language around the victim language with the Sandberg case. It's concerning because I just because of the Supreme Court's definition of victim with respect to trial, I wouldn't want that to be used against a healthcare professional as well. If there's other language we could use. Before that case, I would have said it's not a problem at all. So that's my input. And I'm sorry, my kid's last day of school is today, so I will have to hop off in a bit. But that's my feedback. Thank you.
Thank you. Brett, you're going?
Yeah, I'd thought about the word victim too, with reference to that case. I think that the reason it matters less to me in this situation is that this statute in and of itself is not going to be utilized for the purposes of trial necessarily. It's really just to be able to give the appropriate care to that child. I don't know that, I mean, victims use quite often throughout the codes, even in cases where we do charge somebody criminally under the statute. So I guess I'm less concerned just because I don't know that the word being in the statute would necessarily ever come up in trial, unless it was a civil case in which the statute would be potentially at issue, I suppose.
And Brett, like I totally think that's right. My only concern would be that that case would be used to say that the healthcare professional didn't act properly because of the definition of a victim based on that case. Not so much that this would be used in trial, but that it opens the healthcare professional up to, or this up for them up to a challenge to their decision.
An alternative, because I think in that Stanford case, if what I understood from our May training is that some of the jury instructions were problematic, and the jury instructions included statutory language that used the word victim, if I recall that discussion correctly. As an alternative here, does someone have an alternative to using victim that you would recommend?
We could say something like an individual affected by, or who has experienced.
Or
What was the first version you said?
Affected by.
Affected by. Experienced, subjected to. Other ideas? While you think about that, Jordan, I don't know how much time you have left to stay, but I do want to ask you before you go, do you have an opinion that you'd want to express to the committee one way or the other on whether you want to see the committee move forward with a legislative proposal like this or not, or where your feelings are in relation to that?
I would defer to everyone else. I don't have an opinion. Thank you for that, though.
Mm-hmm. So to read this out loud with the options that came forward, the minor is affected by sexual intercourse without consent, sexual assault, or incest. The minor experienced sexual intercourse without consent, sexual assault, or incest. Or the minor was subjected to sexual intercourse without consent, sexual assault, or incest. Whitney?
I was thinking too of like using the word discloses, but then I was thinking back to when Stephanie talked about how discloses, I mean, like if that child comes forward and they maybe don't have the words to disclose it. So that was kind of in my head of, okay, well, maybe that's not a great one. Another one that I thought would maybe be like they present with a history concerning for sexual abuse. And that could come from the patient themselves or maybe the person who brings them in that history. So that's the one that I feel a little bit more confident in than discloses sexual abuse.
And how did you word that, Whitney, about the history?
So it'd be the minor presents with a history concerning for either the sexual intercourse, sexual assault, or incest. That's kind of like in the healthcare world, how we navigate a lot of things. It's like their history, like presents with the history, like they share their complaints, but I don't want to say complaints. Yeah. I don't know if you followed that. There was a lot kind of mismatched
that helped me.
sentences.
That helped me put a phrase together if we needed it. So thank you. Brett Irigoyen.
Yeah, I just think that that we're just unnecessarily confusing this statute by trying to redefine the word victim. Victims defined in 4618-243 under the criminal codes as a person who suffers loss of property, bodily injury, or death as a result of the commission of an offense. So, despite that case, it's still defined. It's also used throughout the codes 4624-203 for prompt notification of victims and witnesses of certain offenses. It's a term that's not only defined but understood. And I think if we try to, I don't know, redefine victim in a different sense, it's really just going to confuse things in my opinion. I think the more simple we can keep it, the better.
Curiosity question, Brett. Do you think that in any idea in the next session, if someone would try to change that in those codes? No? Okay.
I don't think so. I mean, that case was so specific to the use of that word, both the jury instructions and, in my understanding, if I remember correctly, throughout the trial, which is typically something that's dealt with in motions in limine, if not just understood by the prosecutors and the defense. That's just not a term to be used. I don't know. I'd be surprised if they took the definition of victim out of 4618-243, just given that it's used in so many of the other codes under 46 and Title 45.
I agree with Brett. I think we use victim in a very generic way in a lot of ways in these fields. We talk about domestic violence shelters or places that serve victims of that kind of abuse. It's like we're not always talking about like a definitive victim in a criminal case. And I think that this would be something that we could easily keep out of jury instructions. We could easily call witnesses to explain the nature of this exam without using the word victim, because we already are used to that at trial anyway.
How's the group feeling about leaving victim there then? Okay. All right. Any other thoughts on language at this point? How about we go to public comment and see if there's any particular public comment on the topic and let that inform any other discussion that you have. Okay. At this time, I'll call for public comment. If you have a comment you'd like to make, please be prepared to spell your name for the record and identify if you represent an organization or someone other than yourself. And if you'd click on the raise hand button at the bottom of the screen there on Zoom to let us know that you'd like to make a comment, I will call on you in the order that the hands are raised. Our first public commenter is Sydney Berry. Go ahead, Sydney.
Hi, my name is Sydney Berry. That's SYDNEY and BARRY. And I'm with the Montana Coalition Against Domestic and Sexual Violence. I know you all have been hearing from Kelson Young on this topic. She was unfortunately unable to attend the meeting today, so I'm stepping in for her. Basically, what she wanted me to relay to the committee is that the coalition supports continuing to work on this idea, and we are happy to continue providing input. On the bill draft itself, Kelson feels like this is a good place to start. The bill draft is a work in progress, but she does feel like it is heading in the right direction. And if anyone has any specific questions about maybe where some of our concerns lie, especially regarding language in the bill or how things would work in practice, she would be happy to talk more with any of you. I can provide contact information, Kelson's contact information to you all. And of course, Hope has it also. So you can get it from Hope. But Kelson wanted me to express that she is happy to kind of explain where we stand a little bit more if anyone wants to talk more about it. So that's all I have. Thank you very much.
Any other additional commenters at this time, please click on the raise hand button at the bottom of the screen. I don't see any other public commenters at this time, so we'll close public comment on this topic. And Christina, I see you have your hand raised.
So I think it would be helpful to have the coalitions in, concerns or sort of for this committee. And I'd be happy to get that done before the next meeting. She says.
Your thoughts or comments on this? Whitney, I see your hand up.
Yeah, I've been thinking about it a lot over the last couple of months, and I do think this is an issue that's really important. And it's with the healthcare workers, we're the ones who are kind of dealing with this issue right away. We could be one of the first people that interact with a patient who's experienced this. And I have thought of situations where this has come up about minors consenting on their own to healthcare following a sexual assault. I've also heard of other situations across the state where minors, are they able to consent to this? Are they not? As someone who does a lot of teaching of nurses across the state, this is something that comes up frequently of a gray area, and it's hard to give someone new to the field a concrete answer of whether or not they can allow a minor to consent to this, or do they need parental consent. And I always come back to, it depends on your hospital and the legal team at your hospital. And I do feel a little defeated every time I have to say that. So I do think it's important. With that being said, I recognize that the risk that we're taking of bringing awareness to the minor consent law and how that has the potential to backfire. I don't have a good answer on which way I'm at. If I'm kind of stuck in the middle, like at a fork in the road, if I want to move forward supporting it or pulling back a little bit. I do think it's great that we're starting this conversation and having a potential draft bill in the back pocket in case we do want to move forward with it. I know that if we don't, we're not going to be able to move forward with anything last minute. So that's kind of my thought on it. I don't have a great answer. I don't think anyone got a great answer out of my spiel right there, but those are all my thoughts that I'm having and have had for the last couple of months.
Holly, Megas?
I would agree with like what Whitney said and how medical approaches this, and it really does depend so much on hospital legal teams and how they interpret what is available. And so I think that that can cause a lot of difficulty when we've got multiple people who interpret the same thing differently and what that can mean for the care of patients, but also being in that area of like, if this goes wrong, the places that view the statutes and case laws as is in support and able to do these exams, could they lose that possibility? And then do we lose the ability to serve patients that we are currently seeing? Versus if this goes the way we want, or the way we hope that it goes, I should say, being able to serve more people who could come in and get this care, but they now can't because they aren't supported at home, or they don't have a parent who believes them or who's willing to bring them, or they are in fear of like what that disclosure would mean for their family. I would be willing to help Christina work with Kelson to see like what they think this could be shaped into or what their hopes are. And I think that truly the medical community, when like I talk to other program leaders about these things, is kind of split. We're all sort of in this gray area of we've got hospitals who are like, it can't get any worse. Like we can't provide this care and it wouldn't change, to hospitals being like, well, we could lose sort of the gray area that we get to dance in to do these exams.
Dina?
Dana or Christina?
Christina, sorry.
Okay. I want to be Dana when I grow up, but no. I gotta say that this one in particular really does scare me. And I've been scared of it for as long as I can remember. And I don't know that it isn't our job to try to change that if we possibly can. I think I think part of the paralysis, that the reason we even have to have a SARN network, is exactly these moments. But this is something that we have been, I am torn about whether or not making decisions from a fear base is ever a good thing, you know? But I am scared. So, it's not that I would just be lying if I didn't say that you know, I would be shattered if we did something to make this any worse. At the same time, I don't know how we can make it better if we don't, if we base it on what we're so scared of. I don't know. Doesn't make any sense. Sorry.
That makes total sense, Christina. To me, anyway.
I agree. Like, I feel like that really demonstrates where a lot of the medical community is sitting with how do we take steps forward or not take steps forwards. And we can't live in fear. We've got to like move past that. But it's really gut wrenching to like try to take that first step, moving past that space of fear.
Stephanie?
I think the other thing to consider is maybe it's not about letting fear guide whether we make changes that are necessary, but also being strategic about when we make those changes, what group of listeners we're approaching about it, and if and when we're approaching the right session for change. And I think that's something important to keep in mind when we're taking a risk of losing it all.
Whitney?
That's a good point too, Stephanie. Thinking that if we table this now doesn't mean we're tabling it forever. So I also kind of thought about that as well. I know we have November is a big time for especially for next session in 2027. But good things to keep in mind. Thank you for reminding the team of that.
Just out of curiosity, I'm sorry, I didn't raise.
Oh, you go right ahead.
Okay. Out of curiosity, so do we have a feel across the state for the different disciplines responses? Like, I think the coalition can give us one. I think the nurses associations can give us one. I think prosecutors in general can give us one. Do we all have a feel for how our discipline in particular is sort of viewing this kind of legislation? Or is there some way to get that so we can build more of a, consensus? across the state as to what we need?
Emily and I tried that a little bit with nurses, but we didn't have it was kind of a last minute attempt. And so I don't know when our next meeting is, but Emily and I can continue that with the nurses for sure doing the work across the state. We can try to get a better feel.
Brett, do you have a sense amongst prosecutors at all?
Not really. I brought this to the MCAA board and they were supportive of it. I know this is an issue that we run into on occasion, so I know that prosecutors generally would be in support of it. The ones that I've spoken to, I haven't had any opposition, I guess, from the prosecutor side to doing something like this. Granted, they're not all thinking about it in the context of what the legislature may do to it, or that kind of fear portion that has been discussed. But I'm not the person to talk to if you're looking for a fear-based analysis, because it's just not how I operate. So you guys it's probably good that we are all here and your guys' opinion matters much more than mine do. So yeah, I think it's a great idea, but again, there's potential drawbacks.
So some options could be, we don't have our next meeting scheduled at this time. We could talk about when you might want to come back together. You could have meetings or conversations with folks in your realms of work between now and then. The committee could choose to do a more formal public comment quest in terms of holding, a 30-day public comment period on this draft just to get some feedback and thoughts. I don't know if you feel like it's ready for that, but that's a common step when a body puts forward legislation to take a public comment period before deciding whether or not to proceed. So there are some formal or less formal avenues you could choose to take here, depending on when you want to meet again. And I defer to what your thoughts are on that.
Oh, can you talk a little bit more about what that process looks like? Do they mail in their public comment? How does that work?
Yeah, so those processes that I've been involved with previously is you would put out a formal notice, you'd put out a press release, we would notify our interested persons list, etc. There would be different avenues to get the word out, and then say that the public comment period is open on this date, it closes on this date. If you would like to make comment between now and then, please submit a written comment, either to the mailing address or to our email address. Both would be available. We could choose to put out a survey version instead, or as an additional opportunity, so that there's an electronic form people could just click on and fill out. I have not done it that way before, but it's also been a little bit since I've done public commenting, and change with the times, as they say. So that could be another way the committee could look to do it. There are also times when bodies would hold a public comment meeting, where you would have a formal time announced that, say, a Zoom format meeting would be available for people who wanted to make oral comments. The ones that I've been involved with most recently have done different things as to whether that oral comment becomes part of an official record or whether people are still asked to make written comments in addition to coming to the meeting. There are different ways you can structure it, and it's really up to the committee's thoughts on whether you just want to take written comments or if you want to offer a meeting option to hear oral comments. And then whatever came in, I would amass for you in advance of your next meeting. and post that to you and also on the website publicly so everybody could see and have time to digest the comments. I was learning about the power of silence in that investigations and prosecutions training. So I was just sitting silent, waiting to see what would happen.
I would be interested in trying to get like the nursing leaders together to see like what their thoughts are in places that have programs or that are trying to start programs. But I'm also not opposed if we wanted to open it up for public comment and then use that to continue to shape language. I don't know if other individuals are interested in taking things to their prospective parties to get additional feedback, but I do think it would be helpful, at least from the forensic nursing community, to see what they want, or if they even want this.
Stephanie?
I'd be happy to take this to the CAA board and even forward it on to all the prosecutors around the state to get their take and then report back as well, if that'd be helpful.
Stephanie?
I was just curious, Emily and Whitney, if you guys have an idea of what jurisdictions, I mean, I know that there are some jurisdictions that are, operating in this gray area and some that are refusing to do so. Is there like a general trend, or is it by area, or do you have any idea like I've heard, am I understanding correctly that maybe Bozeman is not? I'm just kind of curious like what the breakdown is in the nursing community for who's operating in the gray area and who isn't.
I don't have any specific answers for like region wise. From my kind of general understanding, there seems to be a lot more people, a lot more entities not working in the gray than there are working in the gray. Yes, it does seem to be a lot more not than a few, which granted, I don't know. I mean, I haven't had contact with all of the hospitals or even all of the places that are providing forensic exams, but from the folks that I have heard from, or even just doing a lot of the trainings across the state, it does seem that minors are not allowed to consent to this kind of care right now.
I would agree with that sentiment. As we go across the state and as we talk to people, I feel like more agencies or more facilities feel like that gray is more not gray and doesn't exist than the gray exists for people to work in.
Okay.
Which was interesting this past 2 trainings ago when we were in Glendive and we had some nurses from North Dakota. Their confidence in being able to provide these exams to minors was so high because they have a very explicit law. I was a little jealous. I'm going to throw that out there. I was a little jealous.
Other thoughts, comments on how you might like to proceed? We have time for a both and stance. You could take time over the summer to talk with your circles of professionals and get a read, and we could come back for a meeting, say in September or August. Maybe time it somewhere around the next Law and Justice September meeting so you have a sense of what that committee is doing with the SARN budget proposal. And then take action after you've had those more informal conversations, if you wanted to move forward, then you could do a formal public comment period. At that time, there'd still be time for that.
I think that that would be a good idea if we take it internally and then decide what happens, and then we could take it to public comment at that point.
Others? No.
I do like that approach.
I do too. I was also thinking I could reach out to our local SART team here in Lewis and Clark County and kind of see a feel for what their thoughts are.
So we'll take a pause for now and gather some more information from your various circles and plan to come back. See that Law and Justice Interim Committee meeting. The date is it's sometime before September 15th because they're required by law to wrap up their work then. It is September 1, Tuesday, September 1. They also meet July 14th. And again, I'll keep you posted if I hear more on when they plan to talk about the SARN proposal. So if we looked at early September, would after the SARN committee meeting, or would you want to meet before the SARN committee? Or pardon me, the Law and Justice Interim Committee.
Like, we are the SARN committee.
We are the SARN committee.
I guess I would probably think before, much as I hate to say that. I hate to say anything about anything during August ever, but
What's the last week of August look like for people? 24, 25, 26, 27, 28? Anybody have any big blocks of expected time away?
I'm going to be out of the country
So that's a
through
yes.
the 27th. Yeah. I'm going to be in Vietnam.
That week looks good for me, but yeah.
Well, how about, because we do have several people not here today, I'll put out a poll with some dates that week, maybe the Thursday and Friday before, and then with a couple of dates after the Law and Justice Interim Committee meeting, and then we can figure out what works. Okay. All right. Well, I think that brings us to the point in the meeting where we have public comment opportunity on any matter within the committee's jurisdiction, but is not on the agenda today. So I'll just ask if anyone in the public, if you have a hand you'd like to raise and make a comment at this time, and be prepared to spell your name and identify yourself and who you represent if it's someone other than yourself. We do have a hand raised. Heather O'Hara. Go ahead, Heather.
Good afternoon, Heather O'Hara, O''Hara. I'm Vice President with the Montana Hospital Association. Listening to your conversation, I would be happy to send out a questionnaire or whatever you would want on behalf of you with the questions you're asking about regarding the gray area. I have a distribution list with all the CNOs and DONs across the state of Montana in our hospitals. So happy to help in any way that I can, so I can bring that information back to you if you're interested. The only thing I would request is that I would like you to come up with questions that I would ask specifically on behalf of you. So happy to help.
thank you.
Other public comment? If you do, please raise your hand at this time. I don't see any additional hands raised. Committee, any continued discussion or consideration at this point, or instructions to me?
Who's going to make the questions for Heather?
I was just gonna say Heather's great to work with, so she's amazing.
I guess my advice on that might be is that could be part of a formal public comment period. Feels like a formal survey that the committee develops. Or if Emily and Whitney, healthcare professionals, wanted to work with developing some questions of their peers as part of their informal insight gathering over the summer and using the MHA's offer as a way to distribute that, could be another venue.
I'd be happy to chat with Whitney or Emily too if they wanted any input or wanted to bounce ideas or thoughts on that too.
Okay, that sounds great.
Well, if there's anything else. School's out for the summer. School's out for the year. School is not out forever. I will poll you on when we come back together. Sorry, now I'm dating myself. So hope you guys have fun camping or doing whatever you get to do this summer in your excursions to rest and recharge and enjoy being outside and hopefully not too windy, slightly rainy conditions at times. So take care and appreciate all of you.
Thank
you too, guys.
Thank you.
You too.
Bye, everybody.
Thanks,
Thank
guys.
you.
Bye.